Now, conflicting court rulings on the health care law. The Federal Court of Appeals based in Washington ruled today that the law does not allow policyholders who get their insurance through the federal exchange to qualify for subsidies that would reduce the cost. But a separate ruling issued hours later by a federal appeals court in Richmond said those getting policies through the federal exchanges do qualify for the subsidies. The rulings come down to different interpretations of the same passage of the law. Congress said if a state did not create its own insurance exchange, the federal government should. But the law also reads that subsidies be provided by, quote, an exchange established by the state. Just 14 states, plus the District of Columbia, created their own exchanges. 5 million enrollees now receive subsidies through the federal exchange. So what do these conflicting rulings mean for the future of the health care law? For that, we turn to Julie Robner of Kaiser Health News and Tom Goldstein, founder of SCOTUSblog.com. Let's go back to the root of this challenge, Julie. Why did this come up?
Well, because people who opposed the law found this what appeared to be a drafting error, saying that the subsidies were only available in the state-based exchange, and decided that they would sue over it to perhaps get another bite at the apple of trying to invalidate or really kind of make a mess of the rest of the law. That's what this comes down to. It's whether or not this was a mistake or whether this was something that Congress intended to do when it wrote just that one sentence about.
And the whole point of these subsidies was to put the A in affordable care, right?
That's exactly right. And if this were to go away, there's an estimate out now that about 5 million people would see premium increases of about 76%. Most of the people who are buying insurance on the exchanges are getting subsidies. Those subsidies are fairly large. If the subsidies were not available, then basically insurance would become unaffordable, and the individual mandate, the requirement for people to have insurance, does not apply to people for whom insurance is unaffordable.
Now, Tom, the D.C. court ruled today that theirs was an unambiguous reading of the law, but yet this other reading of the law seems to open the whole thing to ambiguity.
Yeah, that's right. It's a shock to everyone, I'm sure, that this huge sweeping law that takes up thousands of pages might not be perfectly clear to everyone. What the Court of Appeals in Washington today said is the language says a state-created exchange, and even if it wouldn't make a ton of sense necessarily for Congress to say part of the country has subsidies available to it and a large part of the country doesn't, that's the law that Congress wrote, and our job is just to enforce it. The Court of Appeals in Richmond said, this statute is a mess. There are things that point in different directions about what Congress wanted, and because it's unclear, it's the administration's job to figure it out.
So Congress was the one that opened the door for this kind of a challenge.
Yes, absolutely. Congress did say when there were supposed to be subsidies, but it's just a little unclear whether it literally meant only a state-created exchange, or if instead it meant if you buy your health care through the exchange and you can afford health insurance, we'll help you out.
So if the first ruling were to stand, Julie, we're assuming that the only way to address it would be for every state to set up its own exchange instead of relying on the federal one.
That would be the idea, and there's a lot of discussion already about how states could do that. In some states, so they actually passed constitutional amendments barring them from creating their own exchanges. Remember, a lot of these states run by Republicans really want nothing to do with this law.
Are there other ripple effects that affect other parts of the law as well?
Yes, it actually also affects the employer mandate, the requirement for employers to provide insurance, because that's actually tied to the subsidies that individuals get. The way the employer mandate works is it says that employers only have to pay a fine if they don't offer insurance and one of their employees goes to the exchange and gets a subsidy. So if there's no subsidy, then there's no way to enforce the employer part of this either.
Tom, it seems that we have seen enough challenges now to the health care law, including the part that was upheld by the Supreme Court and the Hobby Lobby decision about a contraceptive coverage that we saw decided in the final days of the court. It seems like death by 1,000 cuts.
Well, so far,
or attempted death.
Exactly right. There's certainly a lot of people who are very critical of the law. They've brought very sophisticated legal challenges. The statute has been upheld by and large. This is the single greatest threat to the reach of the statute, to the attempt to help a lot of people be able to afford health care through insurance. But it is a part of the law that people find offensive in many parts of the country because they don't want the federal government so involved. It's probably going to be up to the Supreme Court, just like the last major challenges.
Are there other challenges in the pipeline, Julie?
There are a couple at lower courts. It's not entirely clear that this would produce a requirement for the Supreme Court to take the case. The administration is going to appeal to the full appeals court.
Tell me how that process works. So we're talking about two different courts in two different circuits today, and then what?
Well, right now, immediately, this was a 3-judge panel of the Court of Appeals, and they will appeal to the en banc, to the entire appeals court. And generally, there are more Democratic appointees than Republican appointees there. There is at least a perception that it's likely to be reversed by the full appeals court, and then you would have basically two appeals courts having ruled and not disagreeing. So in that case, the Supreme Court wouldn't have to take the case, but not clear whether they would.
Well, remind us again, Tom, the way this works. The court then, at what point does the court have to decide whether it would intervene in this?
Well, someone has to ask. So the plaintiffs who lost in Richmond today are inevitably going to ask the Supreme Court to step in. The government could go straight to the Supreme Court, but the White House said today that it's going to ask the full Court of Appeals in Washington to hear the case. So we're probably a year to 18 months away from getting a final answer. The Supreme Court could stay out. I think it's a little bit more likely that they'll just say this is so important, and there'll be enough people on the court, enough justices who are concerned about this issue, that they'll decide to take it up. But it's an open question.
Why would this be as important or more important than any of the other challenges we've seen so far? Why would the court feel compelled? You don't think the court would be compelled?
My guess would be is that if there's no split in the circuits, that the court would not really want to go back and revisit this again, unless they think they could change the decision that they got in 2012.
The most immediate question, however, Julie, for people who are watching this tonight is, how does this affect me? If they have their employer-covered insurance, it doesn't affect them at all.
No, and actually, even if they have subsidies in the federal exchange states, it doesn't affect them immediately. The way the rules work in the D.C. Circuit is that they don't even send the requirement back down to the district court, which is who would actually implement this, for 45 days to give the government time to appeal to the full appeals court, which we now know that the government is going to do. So obviously, this is not going to happen right away. It would be a very long time before people would actually start losing their subsidies that they're getting now.
And potentially, how many people are we talking about who could be affected by these rulings?
5 million.
5 million who are currently in the federal exchange.
That's exactly right.
But are there others who are lined up? But we know how many people, there's so much discussion about who is registering at what pace for a long time there. But do we know if there are others who will also be affected?
Well, as more people would join the federal exchanges, obviously it would affect more people there. I've seen some numbers that go into 2016. So, I mean, it's everybody who's getting the subsidies now and everybody who's potentially eligible in those 36 states where the federal government is running the exchange.
And then we have all the employers, as you mentioned, who wouldn't be subject to the mandate that's going to come into effect in the future that they provide health insurance, because none of their employees would be getting subsidies in those states.
Is there a timetable for the courts to act again?
No, the Court of Appeals can take its time in deciding whether to have the whole court hear the case. Most likely, everyone's sensitive to the question of whether it'll go to the Supreme Court. I think you're looking at 18 months is the best guess for when we'll have a final answer.
Oh, good. Oh, joy. Can't wait. Tom Goldstein of SCOTUS Blog, Julie Robner of Kaiser Health News, thank you both very much.
Thanks so much.